Good day, class. Today we will talk about the law on contracts, which will be covering chapter 1 to 5 of our book. Now, when we say contracts or contract, it is the meeting of the minds between two persons to give something or to render service. If we go back to the law on obligations, when you talk about contract, it is one of the sources of an obligation. So a contract is only a source of an obligation, and if we go back to the definition of obligation, that is to give something or to render service. So again, a contract is a meeting of the minds between two persons to give something or to render service. Therefore, by legal definition, a contract is not a document, it is not a paper, but it is a meeting of the minds between two persons. Now, what are the elements of a contract? There are three elements. There are what we call the essential elements, the natural elements, and the accidental elements. Now we go to the essential elements. What do you mean by essential elements? So when you say essential elements, these are the elements that if they are not present, the contract cannot exist. Now, what are the essential elements of a contract? Now, of course, we have consent of the contracting parties. We have object certain, or the subject matter of the contract, and we have cause or consideration. Although in some contracts there are also some other essential elements such as form and delivery. So when you talk about contracts which necessarily need form, we have contract of sale of lands, or contracts involving lands, or contracts involving donations. There are these contracts have a specific form or format specified by law, and there are also some contracts wherein delivery is considered an essential element. So what are these contracts? We have the contract of sale. So when you talk about sale, there is always a need for the delivery of the object matter of the object or the subject matter in order to consummate the sale. So again, the essential elements of a contract, there are three. We have consent, object certain, and the cause or consideration. We will tackle all the essential elements later on, one by one. Now, the second kind of the second element of a contract are what we call the natural elements. So first we have essential elements. Second, we have natural elements. When you talk about natural elements, they are found in certain contracts and they are presumed to exist unless stipulated otherwise. Now, what are examples of natural elements of a contract? Now, for example, in a contract of sale of land, there is a warranty against eviction. Now, if you buy a piece of land, it is presumed, that you are now, it is already presumed and assumed that you are the owner of such land, and the seller guarantees that you will not be evicted from that property. So that is a warranty against eviction, a natural element in a contract of sale. The third kind of element in a contract is what you call accidental elements. Now, what do you mean by accidental elements? These are various particular stipulations that may be agreed upon by contracting parties. So when you talk about accidental elements, these are provisions or agreements in the contract, agreements in the contract or stipulations in the contract which were agreed by both parties. So again, the three kinds of elements of a contract, we have the essential elements, the natural elements, and the accidental elements. Okay, now we go to the classifications of a contract. Now there are 7 classifications of a contract. First, we have according to perfection or formation. Now, contracts according to perfection or formation, we have consensual contracts, meaning these contracts were perfected by mere consent, meaning the fact that the contracting parties already gave their consent, it perfected the contract. We also have real contracts. These are perfected by delivery, just like in a contract of sale. The contract is perfected the moment the object of the sale or of the contract is delivered. And we have formal or solemn contracts. These are contracts which have special formalities, and these special formalities are essential or important before the perfection of the contract. Okay, so before we go to that, now let's go to the stages of the contract. What do you mean by perfection? No, so there are actually 3 stages in a contract. We have the preparation, the perfection, and the consummation stage. So when you talk about preparation, these are the preparatory steps. Now, for example, in a contract of sale, what are the preparatory steps in order to start the contract? So you have your offer. No, you offer, the seller will offer the buyer the amount or the price of the object. No, so that is the preparation. The moment that the buyer accepts the offer, then there is already perfection. Why? What do you mean by perfection? Perfection is the meeting of the minds between the two contracting parties, meaning they already agreed, they already acceded, they already consented to the agreement that was made during the preparation. And last stage is the consummation. So what do you mean by consummation of a contract? This is when the terms of contract are performed and the contract is fully executed. So the moment na the seller delivers the object and the buyer gives the agreed price money, then the contract is now considered consummated or terminated. So those are the 3 steps of a contract. So we go back to the classification of contract. So perfection. Contracts are classified according to the perfection. So number 1, again, we have the consensual contracts. The fact that the parties already consented to the contract, the contract is already perfected. Second is real contract, wherein the perfection can only come when there is delivery of the subject matter. And another kind of contract according to perfection is the formal contract, wherein if the special formalities, the format, the form is already complied with, then the contract will be perfected. Now, for example, in a deed of donation, it states there that the donation and the acceptance of the deed of donation shall be in written form. So if the donor writes a deed of donation, but there is no written acceptance yet from the donee is the one who accepts the donation, then the deed of donation or the contract of donation is not yet perfected, because the deed of donation is a formal contract. So a deed of donation is an example of a contract which needs form. Okay. So the second classification of a contract is the parties obligated. Now there are 2 kinds of this classification of contract. We have the unilateral contract and bilateral contract. From the term itself, unilateral, only one person has an obligation. However, when you talk about bilateral contracts, both parties require to render reciprocal obligation. So, in a unilateral contract, from the term itself, unilateral, uni, usara. Bilateral, by, duha. So, that is a classification of contract. Now, another classification of contract is as to the cost. So, there are three kinds of contract under this classification as to the cost. We have the onerous contracts, gratuitous contracts, and remuneratory contracts. Now, what do you mean by onerous contracts? There is an exchange of consideration. A contract of sale is an onerous contract because the seller gives the object, at the same time the buyer pays for the object. So it is considered an onerous contract because both of the parties have to exchange. Okay. We have gratuitous contract. There is no consideration received in exchange for what is given. Meaning, usara ang ning hatag. Now, deed of donation is a gratuitous contract because only the donor has the obligation to give. Okay? The donee only has it's not really an obligation, but the privilege to receive. That is why it is considered a gratuitous contract. And we have remuneratory. Something is given for the benefit or service that has been rendered previously. So these are, of course, remuneratory. These are service contracts. And an obligation to do something, in an obligation to render service. After giving your service, there is there is an obligation, of the other party to pay for the services rendered. Now we have another classification of contract. We have the risk of fulfillment. Now there are two kinds of contract under the risk of fulfillment classification. We have the commutative contract and the aleatory contract. Now, what do you mean by commutative contract? Equivalent values are given by both parties. We have, we have 1 kilo of fish for 250 pesos. So that is commutative contract, equivalent values. Now, when you talk about aleatory contract, the fulfillment of contract depends on chance. Now, what is an example of an aleatory contract? A contract that depends on chance. We have the contract of insurance. In a contract of insurance, you pay the insurance money, and in case you have sickness or the insured person dies, then the insurance company now has an obligation to pay the insured. But if the insured person does not have any sickness or disease, or does not die on a specific period of time, then the insurance company also will not be obliged to pay the insured. So an aleatory contract, again, is a fulfillment of a contract which depends on chance, and that is agreed upon. Now we have another classification, which is importance. When you talk about importance, we have the principal contracts, the accessory contracts, and the preparatory contracts. When you talk about principal contracts, the contract can stand alone. For example, in our activity, we have a contract of loan. A contract of loan is a standalone contract. Now, what is an accessory contract? Its existence depends on another contract. Now, in a contract of loan, what is the accessory contract? The accessory contract in a contract of loan is a contract of guarantee. In a contract of guarantee, a third person promises that if you cannot pay, the third person will pay. Now, in a contract of guarantee cannot exist without a contract of loan. That is why it is considered an accessory contract. Or we have another kind of contract according to importance. We have the preparatory contract, wherein the contract is not an end by itself, but a means through which other contracts may be made. For example, a contract of agency. So in a special power of attorney, that is a preparatory contract. What is in a special power of attorney? You are representing you are representing a specific person to do a transaction, and it is considered a preparatory contract because a contract of agency is just a start before going to the principal contract. Now, for example, in our contract of loan, a preparatory contract could be a special power of attorney wherein the person who is the actual borrower will authorize his wife or her friend to have the loan in her behalf. So it is a preparatory contract because that is not the main purpose of the transaction, but it is only a means in order to achieve the principal contract. So that is a contract according to importance. Now we have contracts according to name. I think that's self-explanatory. We have nominate contracts, contracts which have names, contract of sale, deed of donation, contract of partnership, and we have innominate contracts. These are contracts that do not have special names or titles. Although we will okay. So when you talk about innominate contracts, they have no name compared to a nominate contract. Now, what are the kinds of innominate contracts? So, I give that you may give. I do that you may do. I give that you may do. And I do that you may give. So, these are the kinds, no? Muhatag ko para muhatag ka. Mubuhat ko para mubuhat ka. Muhatag ko para mubuhat ka. O mubuhat ko para muhatag ka. No? So, there are no specific names for these kinds of contract. Now, how are the innominate contracts ruled? If wa si Jai specific nga, like for example, law on partnership. Partnership is a contract. Law on corporations, it is a contract. So, what are the rules for innominate contract? Number one, of course, agreement of the parties. Because again, the number one essential element in a contract is consent. So, the moment there is agreement of the parties, then it is the rule. One of the rules in an innominate contract. Then, of course, we have the law on obligations and contracts, which are generic in nature. We have rules on the most analogous nominate contract. So, kung igtanaw nimo sa contract nga wayngan, mura siya og contract of sale, pwede ra nimo i-apply ang contract of sale kung duol-duol jud ang inyong sinabutan to a contract of sale. And lastly, customs of the place. Kung unsay naandan ana nga lugar nga buhaton with regards to that specific contract. So, those are the rules for innominate contracts. Now, the last classification of a contract is regarding their subject matter. Now, we have contracts involving things. We have contracts involving rights and credits, and contracts involving service. So, when you say involving things, rights, and credits, these are contracts in order to give something. And of course, contracts involving services, this is a contract where involves the rendering of services. Okay, so those are the classifications of contracts according to different matters. So, what are the basic principles or characteristic of a contract? Of course, number one, a contract, because it is an agreement, there is the principle of autonomy. So, what do you mean by principle of autonomy or the liberty to contract? It means that the parties have the freedom to stipulate whatever they want in a contract. So whatever they want, whatever they have agreed into. However, there are of course always exception to the rules. The parties may stipulate any form, any form of any kind of stipulation, as long as it does not violate the law, morals, good customs, public order, and public policy. For example, you have a contract to kill for 50,000 pesos. Can you, 50,000, yeah, a contract to kill a person for 50,000 pesos, is it covered by the principle of autonomy? No, as we have said, that is an exception to the rule. The act of killing a person is against laws, morals, good customs, public order, and public policy. Therefore, it cannot be stipulated in a contract. So that is an exception in a principle of autonomy. Another principle or characteristic of contracts is the mutuality of contracts. When you say mutuality, both the contracting parties are bound by the contract. So dili pwede nga kamong duha ning enter into a contract pero usa ra ang bound, ang usa dili mo follow. So under the principle of mutuality of contracts, both of the parties should follow and should comply with the agreements or stipulations provided in the contract. The third principle or characteristic of a contract is the relativity of contracts. Now, when talk about relativity of contract, it's basically connected with mutuality, because when you talk about relativity of contracts can only take effect between the parties. So if the contract is made by A and B, then only A and B are bound by the contract. Of course, their assigns and their heirs are also bound by the contract, because the rights of a contract are transmissible. However, there are exceptions to the rule. There are 4 exceptions to the relativity of contract. So again, when you talk about the contract, relativity of contracts, only the contracting parties are bound by the contract. However, there are 4 exceptions to the rule. Number 1, we have stipulation po atwa. Second, we have contracts creating real rights. Third, we have contracts that defraud creditor. And fourth, tort interference. Now, these are exceptions to the relativity of contract. Now, what do you mean by stipulation po atwa? Por atruwi. So, it is in a contract, there is a stipulation in favor of a third person. Now, for example, A and B had a contract of loan. A is the creditor, B is the debtor. So, supposed to be B will pay A the amount of the loan. But there is a stipulation po atwa. So, it states there that instead of B paying A the debt, B will give the borrowed money, not the debt. B will be paying C, who is a friend of A. So that is a stipulation in favor of a third person. Waon tay labot si C sa ilang agreement, but kagibutang si C nga siya ang makadawat sa bayad ni B, then that is an exception to the relativity of contract. Si C, bisag wa siya ilabot sa contract because stipulated siya and maka-benefit si C sa contract, then that is a stipulation po atwa. So the stipulation must only be a part, no? But not the whole of the contract. So dili pwede part ra. So kato sa atong example in a contract of loan, B will pay C the around 3 monthly installments, no? So naagi hapoy makuha nga favor si C. So both parties must conferred upon a favor of the third person. So meaning nagkasinabot ang both parties nga ihatag sa third person ang benefit. The third person must accept and say it to the debtor before its revocation or cancellation. So C will then communicate to B nga, okay, I will accept the 3 monthly installments given to me in the contract of loan between A and B. And neither of both parties be the legal representation or authorization of the third person. So, dili pwede ha nga. In the stipulation po atwa, what do you call this? The payment of 3 monthly installments should be given to C, but C will authorize A. No. So, A and B should not be, the main contracting parties should also not be the representatives of the third person. So, those are the requisites in order to have a proper stipulation po atwa. Now, the second exception to the relativity of contracts is where contracts which create real rights. Now, for example, in a contract of mortgage, no? In a contract of mortgage, what is, for example, A mortgage the property of B to C. So, when you say mortgage, giprinda ni A ang property ni B, padong dito ni C, kinangutang si Ja. Si B agreed, B agreed, he issued a special power of attorney allowing A to mortgage the property. So, even if in the contract of mortgage, it is only between A and C, but because the mortgage creates a real right, meaning na ay right si C sa property in case dili mo bayad si B, then si B, bisag wa sa jay labot sa contract of mortgage, he is bound by the rule, by the contract, and he cannot use the relativity of contract as an excuse. Meaning, dili ko pwede mo, wa ko'y labot ana, kay wa mo ko'y labot sa kontrata. But the fact that you agreed that your property be mortgaged by A, then you are part, because the contract created a real right. Now, the third exception in a contract that in the relativity of contracts is a contract that defrauds a creditor. So, we already talked about this last time, no? In cases of action Pauliana. So, for example, si A could no longer pay B. So, what he did, ang ilang last nga remaining land, ija tahang baligja ni C. So, si C can file for annulment of the contract bisag wa siya labot sa contract. Kaya pwede raw makapa-void sa kontrata is ang mga contracting parties. But if it is a contract that will defraud the creditor, then through an action Pauliana, C B can go against the contract between A and C despite B not being a part of the contract. And lastly, the last exception to the relativity of contract, we have tort interference. When you talk about tort interference, this is a case wherein a person induces some other person to violate his contract. For example, a basketball player has a 5-year contract with what do you call this? For example, with Lakers, he has a 5-year contract with Lakers. Now, here comes an agent, and the agent will say, break your 5-year contract with Lakers. I will give you a bigger offer. And you break off your agreement, bisag wa pa'y 5 years, and you transfer to us. That is what you call tort interference. And the person who seduced or who induced the contracting party to breach the contract will also be made liable. So that is tort interference, and that is another exception to the relativity of contracts. Now, the last principle or characteristic of a contract is the obligatoriness of a contract. When you say obligatoriness, meaning you are obliged. So once the contract is perfected, then it has the force of law between parties which are bound to comply in good faith. Meaning, The moment nga ma-perfect na ang contract, nagkasinabot na mo, bisan og wa pay suwat-suwat sa papel, under the obligatoriness of a party, you are now bound and you are now obliged to comply with the contract. Okay. So those are the principles or characteristics of a contract. Now let's go back to the elements of a contract. Again, we said there is consent, there is subject matter, and there is consideration. Okay. Now, we go to consent. What is consent? It is meeting of offer and acceptance upon a thing. Okay. So, when you say consent, you agree. You agree. Okay. So, what are the requisites of consent? So, it must be given by 2 or more parties. So, meaning both of you should give your consent. Parties are capacitated to enter into a contract. Now, who are parties who are capacitated, who can enter into a contract? Now, why is it in a contract? It states there, Jeline Gail Paler Acasio of legal age. So, why do you have to have the provision or the phrase of legal age? That is in order to show that the person entering to the contract has the capacity to actually be a contracting party. So again, those who can has the capacity to enter into a contract are those persons who are of legal age. So the legal age is 18. And there is no vitiation of consent, meaning wa gajud ka pugos. And then there is no conflict between declared and intended, and the legal formalities must be complied with. Okay. Now, who are the persons who cannot give their consent? Kinsa may dili pwede makahatag og consent, or if they enter into a contract and they cannot give their consent, it means that the contract is voidable. So, who are these persons? We have the unemancipated minors, although we no longer have unemancipated minors because under the law, the legal age is already 18. During the time that the Obligations and Contract Law or the New Civil Code was crafted, the age of emancipation is 21. So, now we no longer have unemancipated minors. Okay. Other persons who cannot give their consent, those who are insane or demented persons. Nga naman, why can an insane person not give their consent? Of course, because an insane person cannot distinguish fantasy from reality. So you cannot enter into a contract with an insane or demented person unless he is in lucid interval. No, di ba na ay mga insane, na mga buang nga mag-andar-andara. So, sa time nga ning enter mo into a contract, wa si dyan ning andar sa iyang pagkabuang, then he is allowed to enter into a contract. However, if he is having his schizophrenic episodes, then he cannot enter into a contract. When you say a demented person, that is not insane. But a demented person has a difficulty to distinguish what is right from wrong. And lastly, we have deaf mutes who do not know how to read and write. Nga namang dili man makagive og consent ang mga deaf mutes who do not know how to read and write because they are prone to being defrauded. No, dali sila mailad, kay dili sila makabasa, dili sila makasabot sa unsay gisabutan. So again, minors, insane, demented persons, and deaf mutes who are illiterate cannot give their consent. Okay. So, those are what you call, those are persons who cannot give their consent. Now, in a requisite for a proper consent to be given, it says there, it must not be vitiated. So, unsa man ang vitiated? What are the vices of consent? Meaning, when you talk about vices of consent, what are the things that could make kung may consent defective. No, kung may consent defective. There are 5 vices of consent. We have mistake or error, fraud, violence, intimidation, and undue influence. Now, when talk about mistake, you entered into a contract kay nasa job ka, nagtuo ka, but sa job di ay. So, it means that your consent is defective. Nagtuo ka nga what you are buying is a diamond ring, when as a matter of fact, it is not a diamond ring, but it is a lobot sa baso, ang bato sa imong singsing. So, there is a mistake or error. No? Because when you talk about mistake, the substance of the thing, there is a mistake in the substance of the thing that is the object of the contract. Now, nagtuo ka nga diamond ring, nagtuo ka nga gold, nga pawnable, but what you bought is a fake nga ring. So, there is a defect in your consent. So, that is mistake. Second, we have fraud. We all have always discussed what is fraud. Fraud is pangilad. Kung nailad ka in order to enter into a contract. So, it means na kung nailad ka, then the consent is defective because you did not freely enter into a contract, or even if you entered into a contract, giilad man ka. So, nagtuo ka nga tinuod or sakto. So, you have there the rules on fraud. Okay? Of course, we have violence. No, what do you mean by violence? Kanang gipugos ka, no, na ay mga irresistible force, gitiunan ka og pusel, gisumbag ka, gikulata ka para ra mosugot to enter into a contract. So that is vitiated consent. There is a defect in your consent. Fourth, of course, we have intimidation. Dili unta ka mo enter into a contract, but ingon ang imong boss nga kung di ka mo enter into this contract, then tangtangon ka na sa work. That is intimidation. Now, that is intimidation. So, the difference between violence and intimidation: violence is external and it talks about physical contact or coercion. Sumbagon ka, kulatahon ka. But when you talk about intimidation, it is internal. There is no physical coercion, and it is only more on mental or moral coercion. And the last vice of consent is undue influence, no? Ganahan na unta ka mo decide freely nga dili mo enter into a contract, but gipa dungog-dungog man ka sa imong mama nga kanang mahiubos jud ko if dili ka mo enter into a contract. So that is, there is undue influence, or for example, your what do you call this, your best friend, no, nga mas bright pa nimo. For example, mingon siya nga, mingon imong best friend nga enter na into that contract, kay baw ko, kay mas kamao ba ko nimo. So that is undue influence. Okay, you did not freely give your consent to enter into such contract. So again, those are the vices in the consent, meaning if any of the 5 are present, then the consent is defective. So again, we have mistake, fraud, violence, intimidation, and undue influence. Okay. And then we have the objects of a contract. The second essential element is object. So we already talked about consent. Now we have the object of a contract. Now, of course, when you talk about object, it must be specific and certain. No? Object is money, object is the house, the object is the property. Or when you talk about service, it is not contrary to law, morals, good customs, public order, and public policy. So we said that if the object is a contract to kill a person, the object is contrary to law, or the service is contrary to law, therefore that is not a valid contract. Or services and things that must not be legally or physically impossible. For example, a deed of sale of the sun, a deed of sale of the moon. Of course, that is not legally and physically impossible. Therefore, it is an invalid or illegal contract. Or services that are within the commerce of services must be within the commerce of man, meaning pwede ibaligya legally. So how can you can you sell your organs? Your organs, no, body organs, your organs in the body are not within the commerce of man. Therefore, you cannot make a deed of sale of your kidneys. That is illegal. Rights that are not transmissible. So, dili ka pwede mo ingon nga ahong ibaligya ang ahong kanang right. Right to a certain property, right to a certain land, if it is specifically stated that it is not transmissible. The object must also be determinate, meaning kanang klaro ba, house and lot located in Matahan, Masin City with lot number 5121, something like that. Or determinable, meaning bisag mo yung sale of a motor vehicle, kasabot ka unsa nga motor vehicle, unsa nga sakyanan ang gibaligya. And no contract be entered for future inheritance. No? So, kay ang kanang mga inheritance, it only takes place the moment the decedent dies. So, future pa man na siya, pa man namatay, so it cannot be made an object of a contract. Nga, kung dahil mamatay na ahong lola, ang ahong mama na nga properties, ahong ihatag nimo. Kung imong lola is only 50 years old, dadyo pagajud kaadyo ang chance nga mamatay siya. So, a future inheritance cannot be an object of a contract. And of course, lastly, we have the consideration or the cause of the contract. Once may rason why you entered into a contract. Now, requisites of cause of a contract, it should be just and equitable. It should exist, lawful, and true. So, in a contract of sale, what is the cause or consideration? That is money. So, that is why we have the rules on lesson. So, when you talk about lesson, there is an inadequacy of cost. For example, you bought 10 million worth of house and lot for only 1 million. So, there is already lesson there. Lesson, it means that there is an insufficient price for the thing sold. Okay. However, the lesson does not invalidate a contract. What if nisugot ra ka nga 1 million kay nagdali jud ka nga mabaligya ang property? So it does not invalidate the contract. However, if the lesson was a result of fraud, mistake, or undue influence, then it violates or it invalidates the contract because consent was vitiated. So again, fraud, mistake, undue influence, violence, and intimidation, these are vices of consent. Therefore, if these are present, then it can invalidate or it can make the contract voidable. Okay, now let's go to the forms of contract. Contract should not necessarily be in writing, and it should not be necessarily in a public instrument. However, the law requires certain contracts that must be in writing in order to be valid. Number 1, a donation of personal property which exceeds 5,000. So, kung mo donate ra ka, meaning muhatag ra ka o property nga to 1,000, pwede ra og so what? Agent's authority in a sale of land or any interest. So, you have to, dahil dili ikaw ang tag-agent sa property, gisugo ra ka o baligya o juta, dili pwede nga storya-storya ra. You need to have a document to prove it. And then we have a stipulation to pay interest on loans. That is why in our contract of loan activity, if you want to have the person pay an interest, then it should be stipulated in the contract in writing, or else it is presumed nga kung unsa ijang giutang mauray ijang iuli. And stipulation to reduce a common carrier's extraordinary diligence and to limit its liability. So we have discussed if you are riding in a public utility vehicle, what the diligence expected is a extraordinary diligence. If you want nga ang public utility vehicle dili extraordinary diligence ang isang i-practice, then it must be put into writing. So again, these are contracts which must be in writing to be valid. And there are also contracts which must be in a public document in order to be valid. When you talk about public documents, these are documents which are notarized by a lawyer. Now, what are these contracts? A donation of real property, both a donation and acceptance. When you talk about real property, these involves lands, buildings, houses. So if you are donating a real property, it must be in a public instrument. Second, sale of real property. So imong i-donate, imong ibaligya ang imong real property, imong juta, imong bahay, imong building, it must be in a public instrument, meaning it must be notarized. And lastly, partnership where real property is contributed, although we will discuss that in the law on partnership, or when the capital contribution exceeds 3,000. That is provided under the rules under Securities and Exchange Commission. That is also provided in the law on partnership. Okay, now let's go to the reformation of contracts. When you talk about reformation of contracts, when you talk about reform, what do you mean? Alid-an, na kay gustong i-change sa contract. Now, the remedy in equity in which a written instrument is made to the real intention of the parties when there is an error or mistake. Now, for example, in your contract, no, ang inyong sabot jud is 1 million. But ang nakasuwat dito kay 5 ra ka 0, nakuwangan og 0. But because your true intention is to sell the property for an amount of 1 million, then you can reform or you can change the contract because there was a mistake. Okay. So what are the cases wherein you can reform? Now, wherein you can reform or you can change your contract. Okay. So first, when there is a mutual mistake of parties, or when one party was mistaken and the other did not act in fraud, or when one party was mistaken and the other knew or believed that the instrument did not state their real agreement. Na nasadyo pang usa and kahibawang usa nga dili gyud tumao ang inyong gikasabutan. Fourth, there is ignorance, lack of skill, negligence, or bad faith of the person drafting the instrument, and he does not state the true intention of the parties. So, ang naghimo sa contract, pwede ignorant, meaning wa siya kahibaw, pwede pod og wa siya makamao, or nagdinanghag siya, or ijang gitujo. Nga dili ang ibutang unsay tinuod nga kasabutan mo ibutang sa contract. So, in that case, you can reform your contract. And lastly, when two parties agreed on mortgage or pledge of personal or real property, but the instrument states the property is sold absolutely or with the right to repurchase. So, for example, ang inyong sabot, iprindara ang property. Kuhaon na ang property kung makabayad na ka, but ang inyong gihimo is deed of sale. So, in that manner, kung inyong intention na jud is prinda, but ang gihimo nga document is deed of sale, then you can reform or change the contract. However, there are certain contracts which cannot be reformed. We have simple donation inter vivos, where no condition is imposed, meaning donation nga mo take effect dajon and wa siya gibutang giingon ra kay ganahan na mohatag because of love and generosity. So dili na siya pwede mausob. Another contract that cannot be reformed is a will. A will can only be reformed by the person who really made the will, the testator. Ang testator, ang naghimo sa will, pwede niya usbon ang isang last will and testament as many times as he wants. But it is only him who can change or reform the instrument. Other persons cannot reform a last will and testament. And the last contract which cannot be reformed is when the real agreement is void. So, for example, you have an agreement to kill a person. So again, the agreement is void. Therefore, dili pwede nimo i-change ang agreement to kill a person for 50,000, himo na lamang nimong 40,000. Because, in the first place, the agreement is void. And that concludes our discussion on the law on contracts for Chapter 1 and Chapter 1 to 5. So, if you have questions, you can send your questions and clarifications in our group chat. You can also comment in the comment section. Thank you and have a good day, everyone.